the transformative character of Kenya's constitutional framework, which envisages a judiciary empowered not merely to pronounce rights in the abstract, but to enforce them in a manner that renders them practical, effective, and meaningful. Of particular significance is the fusion of constitutional and administrative law remedies, which enables the court to address violations arising from both public and quasi-public actions within a unified constitutional context. The jurisdictional issues arising from the application of the doctrine of exhaustion and the principle of constitutional avoidance are addressed in a separate part of this judgment. The specific question presently falling for determination is whether or not the face of the pleadings, from the face of the pleadings, the petition raises constitutional issues anchored in the Bill of Rights so as to properly invoke the jurisdiction of this court under Articles 22, 23, and Article 165(3)(b) of the Constitution. In this regard, the court must undertake a preliminary examination of the petition to ascertain whether it discloses an arguable case that a right of fundamental freedom guarantee under the Constitution has been denied, violated, infringed, or is threatened. Only where such a threshold is met does a court constitutionally mandate to intervene under its human rights jurisdiction properly arise. In the circumstances, this court bears the duty to interrogate the true nature of the dispute and to discern the substantive character of the petitioner's case, with a view to determining the most appropriate reliefs, if any. In undertaking that task, the court must first be satisfied that it is properly seized of jurisdiction, not only to entertain the petition, but also to grant the reliefs sought. Jurisdiction is not assumed. It must be affirmed, established, and it is right that a court must down its tools the moment it determines that it lacks jurisdiction to proceed. The jurisdictional principles are found in the cases that we have cited, including Samuel, Basharia, and another, versus the Kenya Commercial Bank, Kenya Limited. I'll not read that text, it's there. Upon careful examination of the relief sought in the petition as reproduced in this judgment, this court notes that none of the prayers enumerated from A through to J expressly invoke or anchor themselves upon a specific right or fundamental freedom guaranteed under the Bill of Rights, which the petitioners allege have been denied, violated, infringed, and or threatened with infringement. The absence of such express linkage raises legitimate questions as to whether the petition in its formulation meets the threshold for enforcement of rights under Articles 22 and 23 of the Constitution. This court further observes that while the petitioners allege a breach of Article 27 at paragraphs 39 and 47 of the petition, and refer to a breach of Article 35 at paragraph 50, with a suggestion, though not an express citation, of Article 54 at paragraph 41 in contention with the alleged failure to include persons with disabilities in the nomination lists. These constitutional claims are not properly anchored to or reflect in the reliefs sought. There exists a discernible disconnect between the alleged infringements and the prayers framed, thereby diminishing the coherence and the specificity required in constitutional claims. It is not sufficient to merely allege a breach of constitutional provisions. The reliefs must be logically and legally traceable to those alleged violations. Similarly, while the petition makes reference to Article 28, which guarantees the right to dignity, and Article 47, which secures the right to fair administrative action under the section titled Legal Foundations of the Petition, these provisions are neither invoked nor particularized under the substantive section of the petition in the title Contravention of the Constitution and various statute laws, which span from paragraphs 31 through to 51 of the petition. This omission reflects a lack of precision and coherence in the formulation of the alleged violation of the Bill of Rights, thereby undermining the clarity of the claims and the ability of the court to ascertain whether a justiciable issue properly invoking its jurisdiction has been established. In the considered view of this court, the apparent disconnect between the alleged violations of constitutional fundamental rights and freedoms in the relief sought is in large part attributable to the petitioner's failure to enjoin critical parties to the proceedings, most notably the IEBC selection panel, the Parliamentary Service Commission, which acted as the secretariat to the IEBC selection panel and the appointing authority. It is manifest that the actions or omissions giving rise to the alleged breaches of the rights, if any, would lie at the feet of the IEBC selection panel and or the appointing authority. The non-joinder of these necessary parties therefore undermines the effectiveness of the petition and renders it procedurally deficient insofar as constitutional accountability is sought against entities that are not before the court. In the absence of a clear demonstrable nexus between the alleged breaches of the Bill of Rights and the relief sought, this court is unable to properly characterize this petition as one that has been rightly, competently brought under the provisions of Articles 22 and 23 of the Constitution. It is now well established that a constitutional petition must not only cite the relevant constitutional provisions, but must also plead with specificity the manner in which such provisions have been violated, infringed, or threatened, and must further link those alleged violations to the remedies being pushed. The failure to do so deprives the petition of the constitutional coherence necessary to invoke this court's jurisdiction under the said article. This position was articulated in the seminal decision of the High Court in Narita Karimi Njeru versus the Republic, 1975 EKLR. The text is there. I won't have to read, where they reaffirmed the finding of the Court of Appeal in the Mumo Matemu and versus the Trusted Society of Human Rights, and 5 others, 2013 EKLR. Similarly, in the Trusted Society of Human Rights Alliance versus the AG and others, 2012 EKLR, the court, in answering the question of what the courts were to consider when determining the admissibility of constitutional petitions, The first item, the first issue, properly founded under Article 22 of the Constitution. The respondents and the interested parties are in agreement that the petition presently before this court does not properly invoke the jurisdiction of the High Court under Article 22 of the Constitution, which is principally concerned with the enforcement of the Bill of Rights. It is their collective submission that, notwithstanding the petitioner's reliance on various constitutional provisions, including those situated within the Bill of Rights, the petition does not raise justiciable issues capable of demonstrating a denial, violation, infringement, or threat to any right or fundamental freedom guaranteed under the Constitution. In their view, the mere citation of how specific rights have been violated or are under threat of violation is insufficient to trigger the court's jurisdiction under Article 22. The respondents and the interested parties further submit that even where the petition purports to invoke provisions of the Bill of Rights, specifically Article 35 in alleging a denial of the right to access to information, and Article 47 in alleging a violation of the right to fair administrative action, the alleged infractions have not been pleaded with the level of specificity and particularity required in constitutional litigation. They contend that the petition fails to set out with clarity the precise acts or omissions complained of, the manner in which they allegedly contravene the stated rights, and the resultant prejudice, if any, suffered by the petitioners. In any event, they urge the claims are rendered untenable by the application of the doctrine of exhaustion on account of the petitioner's failure to first pursue available statutory or administrative mechanisms for redress. Alternatively, they invoke the principle of constitutional avoidance, submitting that the matters raised are capable of resolution without recourse to constitutional interpretation or application, and therefore fall outside the proper remit of a constitutional petition under Article 22. The petitioners, for their part, maintain that the petition is properly and competently before this court, and that the issues raised therein are justiciable within the meaning and scope of Article 22, 165(3)(b), and 258 of the Constitution. They assert that Article 22(1) vests in every person the right to institute court proceedings, alleging that a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or is threatened by the infringement. Additionally, the petitioners rely on Article 258, which confers upon every person the right to institute proceedings where it is alleged that the Constitution has been contravened or is threatened with contravention, irrespective of whether a specific right in the Bill of Rights is implicated. On that basis, the petitioners submit that the constitutional foundation of the petition is firmly grounded and that the court's jurisdiction has been properly invoked. This court's analysis of this issue must of necessity commence with the express language of the Constitution. Article 23(1) provides as follows: the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial, violation, or infringement of or a threat to a right or fundamental freedom in the Bill of Rights. Article 23(1) of the Constitution unequivocally vests the High Court with the primary jurisdiction for the enforcement of the Bill of Rights and affirms its authority to grant appropriate reliefs where a party alleges or demonstrates a real and imminent threat of a violation of a constitutional right or fundamental freedom. It is within the constitutional framework that the justiciability of this petition must be examined. The court is thus duty-bound to assess whether the pleadings disclose a competent claim grounded in the alleged infringement or threatened violation of the Bill of Rights so as to properly invoke its jurisdiction under Articles 22 and 23. Article 23 of the Constitution sets out the range of remedies available to a court. In view of the foregoing authorities, the failure by the petitioners to articulate how the cited provisions of the Constitution, provisions of the Bill of Rights rather, have been violated or threatened with violation in relation to the relief sought, this court finds that the petition is, insofar as it claims to be brought under Article 22 and 23 of the Constitution, falls short of the threshold required to invoke the court's jurisdiction under Article 22 and 23. We are further fortified on this finding by the Court of Appeals decision in the case of David Sironga Oletukai versus Francis Arap Muge and two others, 2014 KECA 155 KLR. The same principles are echoed in other authorities cited therein: Candy versus Casper Air Charters Limited, Galaxy Paint Co. Limited versus Falcon Guards Limited. And I continue to read. Notwithstanding the foregoing findings, that the petition does not meet the threshold of the enforcement of the Bill of Rights under Articles 22 and 23 of the Constitution, this court is not persuaded that it would be just to dismiss the petition in limine. This decision is informed by two reasons. First, the respondents and the interested parties have extensively addressed the alleged violations of the Bill of Rights, and in doing so intertwined their arguments with the other constitutional provisions. Secondly, and of equal importance, the petition also raises allegations of constitutional and statutory violations beyond the Bill of Rights under Articles 10, 88-2, 232, and 250. These articles touch on the structure, process, conduct of public appointments under the various articles of the Constitution. While relying on the provisions of Article 258 on the enforcement of the Constitution, the petitioners have further invoked the jurisdiction of the court under Article 165(3). This buttresses our opinion as above that the petition in its entirety should be heard and determined on its relative merits. In these circumstances, and guided by the imperative to do substantive justice, this court is satisfied that it ought to consider and analyze the rival positions of the parties on the issues raised, albeit within the framework of the objections raised based on the doctrines of exhaustion and constitutional avoidance, and mindful of the limits imposed by our earlier finding on the jurisdiction under Articles 22 and 23. That's the end of that issue.
Thank you, Honorable Judge. It is also a jurisdictional issue. Thank you.
I will continue to the next one. Whether the petition is justiciable or ripe, or whether it offends the doctrines of exhaustion, separation of powers, and parliamentary approval processes under Article 252 of the Constitution. The first respondent opposes the petition under petition dated 13th May 2025 on the following grounds. The petition is non-justiciable on account of having been instituted contrary to the principles of ripeness. And two, that the petitioners have offended the doctrine of exhaustion, as they have not exhausted the constitutionally provided remedy before invoking the jurisdiction of the Honorable Court. On its part, the third respondent, the National Assembly, contended that the petition is not justiciable for violating the doctrine of ripeness. It was argued that to the extent that the petition challenges an ongoing constitutional process in respect of which no decisional action has been taken by the National Assembly, the petitioners are speculative, and the petition is speculative and deals with prospective anticipatory circumstances rather than current or probable events. The second interested party agrees with the third interested party and argues that the proper forum for the petitioners to have raised their grievances was before the National Assembly during vetting. The respondents argue that this court would be violating the doctrine of separation of powers if it was to direct another organ on how to exercise its mandate, as was underscored by the Supreme Court in the Justice Karaoke Mate and another versus Nyaga Wambora and another 2017 EKLR, as well in Mumo Matemu versus Trusted Society of Human Rights Alliance and 5 others 2013 EKLR. The respondents and the interested parties argue that this court has no jurisdiction to substitute its finding for that of the National Assembly approval process and its ultimate decision in the absence of evidence that the National Assembly disregarded the Constitution and the law. The petitioners maintain that the petition is competently before this court and that the issues raised are justiciable under Articles 165(3)(b), 22, and 258 of the Constitution. They argue that Article 22 grants every person the right to institute court proceedings, maintaining that a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or is threatened. It is their case further that Article 258 grants every person the right to institute court proceedings, claiming that the Constitution has been contravened or is threatened with contravention of Article 165(3)(b), vests in the High Court jurisdiction to determine whether a right, a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. According to the petitioners, the nomination of the interested parties threatens violation of the Constitution and the right to free and fair election conducted by an independent body. Further, that the validity of the nomination process and its outcome is a question ripe for determination by the court, and therefore the dispute is justiciable. The petitioners have relied in the case of the matter of the IEBC 2020 Supreme Court to buttress that argument. The bastion of the power to determine disputes through the exercise of judicial authority and the capacity to commence action for such determination is based on the universal concept of the principle of justiciability. The doctrine of justiciability encompasses such principles as the refusal of the court to make declarations, to assume a jurisdiction over matters which are allocated to such other branches of the government as the legislature and the executive, refusal to decide issues which are not ripe or those which are moot. Under the Black's Law Dictionary, justiciability is defined to mean a matter is proper to be examined in courts of justice, or a question as may properly come before a tribunal or for decision. It further defines justiciable controversy as a controversy in which a claim or a right is asserted against one who has an interest in contesting it. The other definition given of justiciable controversy is a question as may properly come before a tribunal or for decision. In other words, courts should not decide matters that require to be courts will only decide matters rather that require to be decided. We have also referred to a case, Ashwander versus the Tennessee Valley Authority, 1936, American Supreme Court, where it stated that courts should only decide cases which invite a real, honest, and vital controversy. Effectively, the justiciability dogma prohibits the court from entertaining hypothetical academic interests cases. The court is not expected to engage in an abstract argument. It is prevented from determining an issue when it is too early or simply out of apprehension. Hence, the principle of ripeness, and an issue before the court must be ripe through a factual matrix for determination. Conversely, the court is also prevented from determining an issue that has been overtaken by events. When an issue no longer represents an existing or live controversy, then it is said to be moot and not worthy of taking the much sought judicial time. The exception, it must be noted, exists where the court is allowed by law to offer advisory opinions. The justiciability dogma and all principles under it are part of our constitutional jurisprudence. To advance that finding, we refer to the case of John Aaron Mwau versus and three others versus the AG, others HCCP number 65 of 2011, and also the case of Jesse Kamau and 25 others versus the Honorable Attorney General 2010 E. KLRR. We also refer to the case of CORD and two others versus the Republic of Kenya to advance, which advance those principles. I'll go on after those citations. With regard to the several objections raised concerning the competency of the petition, this court reiterates its earlier finding under issue number 1 to the effect that the petition is not properly anchored under Article 22 of the Constitution. However, notwithstanding that procedural deficiency, the court is satisfied that the petition raises substantial and weighty constitutional questions. These include inter alia violations of Chapter 6 of the Constitution on leadership and integrity, Article 28 concerning the establishment, composition, and independence of the IEBC, as well as the constitutionality prescribed procedure for the selection, nomination, and appointment of commissioners to the said commission. It is the finding of this court that at the time the petitioners moved the court, the issues surrounding the nomination, appointment, and assumption of office by the interested parties as commissioners of IEBC were real, live, and justiciable. These issues form the substantive basis of the cause of action. It is also noted that one of the reliefs that the petitioners are seeking is that the court do issue an injunction to restrain the interested parties from occupying office. The assumption of office issue is a live and pending determination. Additionally, while the shortlisting of candidates had already been concluded, the appointment of the interested party by the president had not taken place. We are again fortified by the findings in the case of the Honorable Martin Nyaga Wambora versus the Speaker of County Assembly, Embu, number 5 HCCP, number 3 of 2014, buttressing the same conversations around justiciability. I continue to read. The respondents and the interested parties further argued that the petitioners did not exhaust the available alternative remedies, including the National Assembly. According to the respondents and the interested parties, the petitioners have failed to exhaust all redress avenues available to them under the Constitution and the Standing Order. The petition and application violated the doctrine of exhaustion and are therefore premature. We have again referred to the cases of NASA, Republic versus the IEBC, and others, ex parte. We have also sought and secured guidance from MMM, suing through JMM as a guardian, next friend, Attorney General, and 8 others. Moi Primary School, Kabarak, Nakuru, interested party, petition number 488 of 2023, KEHC 4010 KLR. The principles are set thereout. I continue. With the foregoing background, this court is of the view that the petition is not moot. The same is justiciable and properly before us, pending determination. That's the end of that issue.
Thank you, Honorable Judge.
It is not in dispute that the Parliamentary Service Commission, in its capacity as the Secretariat of the IEBC Selection Panel and the Nominating Authority, are not parties to these proceedings. The interested party and the second interested party and the 5th interested party in particular argue that the petition is fatally defective for failing to join those crucial parties against whom adverse allegations have been made and adverse orders sought. They contend that if the adverse orders sought in the petition are issued, as against the IEBC Selection Panel, the Parliamentary Service Commission, and the President of the Republic, their rights to due process and a fair hearing as enshrined in the Constitution will be violated. On their part, the petitioners argue that Rule 5, Sub-Rule B of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules 2013, provides that a petition shall not be defeated solely for the reason of misjoinder or non-joinder of parties. The petitioners argue that in any event, the IEBC Selection Panel is now functus officio and dissolved, and hence it has no capacity to sue or be sued. We then cite the case of Okoiti versus Attorney General and 5 others, which is a seminal case on non-joinder, and also the Supreme Court's case of Girongo versus Soy Developers Limited and 9 others, the 2021 case. I continue. The petitioners did not sue the IEBC selection panel, the Parliamentary Service Commission, and the nominating authority being the President of the Republic, nor did they apply to amend their petition to introduce those parties. It is our finding that granting any of the relief sought in the petition as against parties whom the petitioners failed to sue would offend Article 50, Clause 1 of the Constitution and thereby create an illegality. This court cannot countenance that, and accordingly, we decline to issue any adverse orders sought against parties not sued in these proceedings. The prayers in the petition that seek those orders must necessarily be dismissed on that basis, and we hereby dismiss the same. The next issue is whether the IEBC selection panel acted illegally by issuing a subsequent expanded shortlist. It is the petitioner's case that Mr. Hassan Nur Hassan, the 5th interested party, was never shortlisted for the interviews and that he was only snuck in through an addendum shortlist, contrary to the selection and nomination process under the Independent Electoral and Boundaries Commission Act. The petitioners claim that the IEBC selection panel acted illegally and in a manner that discriminated against all other candidates. They contend that the inclusion and subsequent publication of the name of the 5th interested party during the course of the interviews, despite not having been initially shortlisted, was procedurally irregular and devoid of any lawful justification. In their view, this act contravened the principles of transparency, fairness, equality, and public participation as enshrined in Articles 10, 47, 232, and 250 of the Constitution, as well as Section 3 of the IEBC Act. The petitioners argue that the manner in which the process was conducted violated their legitimate expectation and that of the public at large, that the IEBC selection panel would at all times discharge its mandate in an open, accountable, and procedurally fair manner consistent with the constitutional and statutory framework governing appointments to independent commissions. On the part of the respondents, they contended that the 5th interested party was amongst the applicants in the long list who applied and was shortlisted for the interview for the position of Commissioner of IEBC, which interviews were held on 24th April 2025 at 12:30 p.m., and that the shortlist, as republished by the IEBC selection panel on 25th March 2025, was in accordance with paragraph 2 of the first schedule to the IEBC Act. In further response, the respondents and interested parties maintain that the selection process was conducted in strict conformity with the relevant constitutional and statutory provisions. They contend that the nomination of the 5th interested party was the product of a rigorous, competitive, and fair selection process undertaken in accordance with the established procedures and criteria. Accordingly, they reject the petitioners' assertions of procedural impropriety or constitutional breach and assert that the process met both the letter and spirit of the law governing public appointments to independent commissions. The question that we must answer from the rival positions above is whether the deviation from the original shortlist through the republication and adding of more names of applicants who were on the long list offended Articles 10, 27, 47, 232, and 250 of the Constitution, and the selection process under the IEBC Act and the Public Appointments Parliamentary Approval Act. Article 10 of the Constitution sets out the national values and principles of governance, which include transparency, accountability, non-discrimination, and inclusiveness. Article 27, Clause 1 guarantees equality before the law and equal protection and benefit of the law, while Article 47, Clause 1 secures every person's right to lawful, reasonable, and procedurally fair administrative action. Article 232, Clause 1 lays down the values and principles of public service, which include fair competition, merit-based appointments, transparency, and representation of Kenya's diverse communities. These principles are replicated in Chapter 6 of the Constitution and more specifically, Article 73 on responsibilities of leadership. We have carefully considered the sequence of events. On 5th March 2025, the IEBC selection panel published a long list of all applicants and a short list containing 92 persons, but excluding the 5th interested party. The 5th interested party was, however, number 985 on the long list, which is reproduced at page 230 of the petition. The total number of applicants was 1,356. Subsequently, on 25th March 2025, the IEBC selection panel republished the shortlist with 6 additional names, comprising the 5th interested party and 5 others. The name of the 5th interested party is number 4 of the interviews slated for 24th April 2025 at 12:30 p.m., and this is contained at page 325 of the petition. The expanded shortlist was accompanied by a public explanation, which is reproduced at page 320 of the petition, indicating that the revision of the shortlist was made to further enhance compliance with the constitutional principles of regional balance, representation of the youth, and overall inclusivity. The first schedule to the IEBC Act, at paragraph 5, empowers the selection panel to regulate its own procedure, provided that such procedure complies with the constitutional and statutory requirements. The petitioners referred us to paragraph 2 of the first schedule to the IEBC Act, which nonetheless makes no reference to any procedure to be adopted by the IEBC selection panel. Neither did the petitioners point out to this court any specific procedure which the IEBC selection panel allegedly failed to adhere to in their selection of the applicants. Notably, the republication occurred prior to the interview stage, and no previously shortlisted or long-listed candidate has come forward to allege prejudice or challenge the fairness of the process. There is also no evidence that the IEBC selection panel acted covertly or arbitrarily. Rather, it took an open, reasoned, and corrective step in alignment with its constitutional obligations. In our humble view, the discretion to revise a shortlist, as was exercised by the IEBC selection panel, in the absence of bad faith and for constitutionally justifiable reasons which they provided by way of an explanation in the republication, does not, per se, offend the law. We then cite cases in which the courts have dealt with previous Sim versus the Attorney General, High Court case 2012, the celebrated case of Mumo Matemu versus Trusted Society of Human Rights, 2013, a Court of Appeal case, and also the case of Republic versus Judicial Service Commission, ex parte Pareno, a 2004 case, which reiterated that fairness and transparency are central to public appointments, but not every procedural irregularity amounts to a constitutional violation. I continue. On alleged breach of legitimate expectation of the petitioners and other candidate applicants, the doctrine of legitimate expectation was extensively considered by the Supreme Court in Communication Commission of Kenya and 5 others versus Royal Media Services and 5 others, 2014 case. It's a lengthy quotation. This court appreciates that any violation of constitutional values would vitiate the selection process. However, in this case, there was no evidence showing that the subsequent expanded shortlist was a substantive procedural deviation which violates rights and caused harm, and therefore this court finds no constitutional violation. In our view, the principle of de minimis non curat lex, the law does not concern itself with trifles, applies in this case. This principle applies in constitutional interpretation that minor deviations do not cause substantive harm, or infringe constitutional values are often not treated as violations that warrant judicial nullification. Accordingly, we find and hold that the republished shortlist did not offend Articles 10, 27, 47, or 232 of the Constitution. On the contrary, the IBC selection panel's action, which was taken transparently and explained publicly, demonstrates a good faith effort to align the selection process with Kenya's constitutional ethos. We further find no evidence of violation of the principles of equality, fairness, or procedural justice. The next issue is familial relations of the fifth interested party with a leader of minority in the National Assembly. Apart from challenging the fifth interested party's selection and nomination on account of his having been shortlisted in the republished shortlist, on another front, the petitioners also contend that the fifth interested party admitted during his vetting by the National Assembly that he is the brother-in-law to the Member of Parliament for Suna East Constituency, Migori County, Honorable Junet Mohammed, who is also the current minority leader in the National Assembly. Consequently, it is the petitioner's case that the fifth interested party is not eligible for appointment as a member of the Commission and that he will not be impartial. The issue for determination is whether the alleged familial relationship between the fifth interested party and Honorable Junet Mohammed, the leader of minority in the National Assembly, is sufficient to create a reasonable apprehension in the mind of a fair-minded and informed member of the public that the said nominee may not exercise impartiality if appointed. It is further necessary to consider whether this alleged relationship was the sole or primary basis for the inclusion of the fifth interested party in the republished shortlist of nominees to the IEBC. It is public knowledge that this allegation was widely circulated in the media, with headlines such as, and we quote, "Godfathers have it," appearing in a publication dated Thursday, 5th June 2025 in one of the daily newspapers of nationwide circulation. Such reports had the effect of framing a narrative in the public domain that the nomination process was influenced by political patronage. Nevertheless, among all the nominees, it was only the fifth interested party whose familial connection to a senior political figure was specifically alleged. The fifth interested party, in his response, admitted to the existence of a familial relationship with the leader of minority in the National Assembly, saying that the latter was his brother-in-law. It is trite law that public appointments must adhere to the constitutional principles of integrity, fairness, merit, and transparency. These principles are entrenched in Articles 10, 27, 73, 232 of the Constitution, as well as the totality of Chapter 6 of the Constitution. Specifically, Article 73, 2A emphasizes that the guiding principle of leadership and integrity includes selection based on personal integrity, competence, and suitability. Additionally, Article 232, 1G requires fair competition and merit as key criteria in public service appointments. More importantly, Article 232 of the Constitution sets out the core values and principles that govern all public service in Kenya. The article mandates that public officers and institutions must uphold standards of professionalism and competence, ethical conduct and integrity, accountability and transparency, non-discrimination and equality, and efficient, effective, and responsive service delivery and the promotion of national values and unity. In essence, Article 232 ensures that the public service operates in a manner that is ethical, impartial, and dedicated to serving the public interest in accordance with constitutional values. These values and principles apply to state organs at both levels of government, as well as state corporations. On the other hand, Article 73 provides for responsibilities of leadership and makes it clear that leadership is a privilege and a responsibility to serve the people. The article mandates that state officers must be selected on the basis of personal integrity, competence, and suitability, and not on connections or influence. Further, public trust demands that decisions, including appointments, be made objectively, impartially, and in the public interest. It follows that state officers must avoid nepotism, favoritism, or conduct that undermines integrity and public confidence. Article 73 calls on state officers to avoid any conflict between personal interests and public duties. The Leadership and Integrity Act 2012 operationalizes Chapter 6 of the Constitution, and specifically, it requires that appointments to state offices must be transparent and based on merit. Nominees must demonstrate integrity, competence, and ethical conduct, and a person with a history or a risk of conflict of interest and who cannot serve independently should not be appointed. Thus, an appointment that appears to serve personal, familial, or political interests may be challenged under these provisions, and therefore it is for this reason that state officers should not place themselves in positions where they might be influenced by relationships or loyalties that compromise impartiality. Furthermore, while the existence of a familial relationship between a nominee and a politician is not in itself a legal bar to appointment, such connection cannot be ignored where it gives rise to a reasonable perception of partiality, undue influence, or political patronage. Public office is held in trust for the people, and the perception of independence and impartiality is as vital as the reality. That said, the Constitution does not impose a blanket prohibition against individuals related to politicians from holding public office. Doing so would risk violating the right to equal opportunity and the principle of merit-based appointments, unless such appointment would raise reasonable apprehension of bias in the minds of a reasonable and informed person. The proper approach is a contextual and case-specific evaluation that considers whether the nominee has demonstrated a track record of independence, professionalism, and transparency regarding the relationship, and whether institutional safeguards against conflict of interest are in place, and whether their appointment would undermine or would conversely reinforce public confidence in the appointing institution. It is this balance between safeguarding institutional integrity and ensuring fair access to public service that the Constitution seeks to uphold. We then quote the Court of Appeal while dealing with the doctrine of bias in the case of Wanjigi versus Chebukati, 2022. It's a lengthy quote. I will not read it in full. In this case, the fifth interested party did not deny the fact that he is the brother-in-law to Honorable Junet Mohammed. The question is whether that was the sole basis for his being selected, shortlisted, and nominated as a proposed member of the IEBC. As we answer this question, we observe that the petitioners have not impeached the fifth interested party's professional qualifications, and neither have they said that he is wanting in integrity. Save for the alleged disqualification under Article 88, 2A1, which is addressed elsewhere in this judgment, the petitioners have not challenged the fifth interested party's overall suitability for appointment as a commissioner of the IEBC. Therefore, while perceived conflicts of interest, nepotism, and bias are legitimate public concerns, they must be grounded in evidence of procedural breach, bias, or influence. Where none of these features exist, and where a candidate has undergone a transparent and competitive process, has been interviewed, vetted, and found to be competent and meeting all other set criteria, family relations alone cannot be a constitutional disqualifier. To hold otherwise would effectively impose an extra constitutional bar based on association, thus offending the principles of equality and dignity of opportunity, particularly where merit has been established. The Court of Appeal in Gachagua and 5 others versus Maingi and 80 others, Civil Appeal number E829 of 2024, consolidated with others, dealt with these very concerns of familial relations. The Superior Court had this to say concerning allegations of bias on account of familial relations, addressing the issue of whether the judges in the High Court should have recused themselves from hearing the case of the impeachment of the Deputy President of the Republic of Kenya, a principle which we find is relevant to the instant petition. It's lengthy. Let me read it from paragraph 197 of that. We fully endorse the findings of the High Court that family members of judges are entitled to pursue independent careers, and such pursuits in of themselves should not cast doubt on a judge's impartiality. Family members of judges, like any other qualified Kenyan, can lawfully be appointed to any public office, and that, per se, cannot be a ground for a judge's recusal, unless it is demonstrated that the appointment was intended to give the appointing authority an undue advantage in judicial proceedings, or for any other improper factor relating to the appointment and the judge's discharge of judicial duties. To suggest otherwise would impose an unreasonable and disproportionate burden on judges and judicial officers. The professional undertakings of a judge's spouse, particularly where they bear no direct relevance to the matter before the court, cannot serve as a valid basis to question the judge's objectivity. In the absence of specific and compelling evidence of a conflict of interest, such allegations amount to mere speculation and fail to meet the requisite legal standard for recusal. End of quote. In this case, we find that the petitioners have not discharged the legal burden of proving the nominee's relation with a top politician influenced the nomination of the fifth interested party, or that he will not be impartial in the discharge of his mandate as a member of IEBC. We then quote the case of Evans Nyakwana versus Cleophas Bwana Ongaro, a 2015 case. Consequently, we find that in the absence of undue influence, interference, or irregularity in the process, the fifth interested party's familial relationship to a political actor or public official cannot, without more, invalidate or negate his selection, nomination, and possible appointment to serve as a member of the IEBC, which is a state office, provided that the selection, nomination, and possible appointment satisfies all other constitutional and statutory requirements. We therefore reject the invitation by the petitioners to declare the fifth interested party ineligible for nomination and appointment as an IEBC commissioner on account of familial relations with a serving politician. Thank you, PGT.
Thank you, Honorable Justice. Individual.
Quite a number. That in every constitutional democracy, the conduct of free, fair, and credible elections is the bedrock upon which